109. In terms of the risk assessment process, Ms. Prince noted that it is not scientifically possible to accurately predict whether or not an individual offender will or will not reoffend, and that the best that can be offered is an, quote, estimate that is anchored to empirical literature specifying features associated with risk and sound clinical analysis and formulation of how those present features might operate in the individual subject to the assessment, end quote. She explained that the process of risk assessment of violent extremism or politically motivated violence is, quote, comparatively new, end quote, when compared to the risk assessment for general violent and sexual offending behaviours. She explained that the assessment of risk of violent extremism, quote, cannot be anchored in the statistical probabilities, and subsequently a numerical score cannot be provided. Rather, the overall risk judgment is based on the clinician's assessment of the available information at the time of the assessment, end quote. 110. The VERA that Miss Prince performed was completed on file information only, and again, Miss Prince noted in that context, open quote, it is recognized that this should be considered an interim assessment only, close quote, and again says, open quote, ... should the opportunity to interview Mr. K avail itself, it is strongly recommended he be invited to participate in interview and assessment, close quote, invitation. She then goes on to state, based on the assessment of all the available information, that, open quote, he is currently assessed as moderate to high risk regarding violent extremism, politically motivated violence, or terrorism activity, close quote. She makes this assessment without ever making any inquiry herself as the defendant as to whether any of the views in issue are currently held by him. So this doctor has made a VERA report assessment based on documented evidence and no physical interview with the defendant whatsoever, therefore determining through the documented evidence that he may be a risk to the state. That's all it is you've become a threat to the state, and they're going to bring out the tar and the feathers, and they're going to make sure that they get away with their crimes. That's all this is. 111. Miss Prince stated, obviously based on the observations of others, that, open quote, his actions thus far have demonstrated his ability to have significant influence through both social media platforms and in real life. He has demonstrated a willingness and ability to recruit others to the cause. He has dedicated all his time outside of work on promoting and supporting the kingdom and detaching from his family. It has had a notable impact on his mental health and his liberty, with his being incarcerated for both a breach of his community corrections order and his index offences. 112. Miss Prince concluded, without really explaining why, that there is a, quote, likelihood, end quote, that the defendant has maintained his belief in the cause and in, open quote, Stephen, close quote, and so, open quote, it is likely that should he be released without any active monitoring case management, he will likely resume his role, close quote. She added again without explaining why that, open quote, whilst residing with his wife and the recognizance order may provide some level of protection in the immediacy, this is likely to have a limited long-term effects, close quote. 113. Somewhat contradictorially, Miss Prince says this, open quote, 124. The impact that Mr. K's incarceration has had on his worldviews is unknown. Whilst incarceration and medication appear to be a significant deterrent, whether he has the will or ability to cease all contact with, quote, the kingdom remains unknown at this time. This is likely further complicated by the potential for Mr. K's more recent experience through his contact with police, the courts, and the mental health services that may have potential to influence an increase in personal grievances which aligns with the greater cause, close quote. Reference 6, Confidential Interim Psychological Risk Assessment Report dated 30 June 2021 at paragraph 124, demonstrating that Her Honour Justice Julia Lonergan has chosen very specifically to document this on the court record. A deterrent. The drugging was used as a deterrent to stop him from having beliefs in something that may put the state into an accountability mode. 114. I consider the first part of paragraph 124 to be a reasonable reflection of the reality, that is, that it remains unknown whether the defendant has or will cease contact with the, open quote, the kingdom, close quote, or not. The second part of the paragraph amounts to nothing more than speculation. 115. With respect to the author, who is not given the opportunity to review and assess the defendant, the report contains much repetition of the comments of others, many assumptions, and much speculation. Even at this preliminary phase, and taken at its highest, the report carries little persuasive weight in assisting the court to resolve whether the defendant presents a relevant risk of committing a serious terrorism offence. Section 25(3)(d). Any report prepared by Corrective Services New South Wales or the New South Wales Police Force as to the extent to which the offender can reasonably and practically be managed in the community.